So it's my happy task to introduce and welcome Frédérique back to the Institute. And Frédérique Ast has been a senior lawyer for the higher authority, the French higher authority on discrimination for many years. The higher authority has regrettably been merged into a body which is not so active on discrimination issues, but I think she still can give us quite a good overview of what's been discussed in the anti-discrimination field regarding issues of religious, ethnic diversity, or also issues regarding disability, although I think your presentation won't touch on that. But she has also published on that, so she has a very extensive list of publications on anti-discrimination issues. And maybe I should say this because this is a social science faculty group, and there is sometimes a little bit of diffidence against lawyers, but I would beg you to think of a lawyer as someone who gets the injuries and the problems in a social justice case, and she or he translates it into legal language before a court. So she will help us today to see that what are the injuries in social exclusion and discrimination in our societies nowadays and in our real lives, and how does it translate into the legal language of the courts. And that's all for my part, and I give the floor to Frédérique.
Thank you. Is it okay? Are you? Yeah, can you hear me? Yeah.
Do you want to?
Yeah. Maybe I should move a little bit. Well, yes, I'm very pleased to be here with you here in Bilbao under the sun. And are you ready for 45 minutes of talk, long talk about cultural diversity within Europe? Yeah? So this is the theme, and I will deal with these questions through case studies, so in a very concrete way. Even if I prepared a very long paper, please stop me, interrupt me after 45 minutes or even a little bit before. You can interrupt me anytime if you want me to precise anything. Please feel free to interrupt me. But first I start. So, yeah, well, the title of my presentation today is about accommodation of cultural diversity in Europe. Cultural diversity is not such a new phenomenon in Europe, of course, but these last decades it has increased due to the migratory flows. The statistics show us that 5.6% of the total population is composed of foreigners, and less than 10% were born abroad. Let's say that 3/4 of all these foreigners around Europe and around the EU, more specifically, are living in 5 member states. That is Germany, Spain, the UK, France, and Italy. And 1/4 of them are citizens of Turkey, Romania, Morocco, or Poland. So the backgrounds are quite different from ours or from the INTEGRIM countries. So here you've got a chart breakdowning the number of foreigners around Europe. And for 40% of them, they are coming from Europe, but the larger Europe, not the EU one. And the other half, let's say, is composed of foreigners coming from Africa or Asia. So the backgrounds are quite different from the one that we used to know in our EU Europe. So how to respond today to this new diversity? Until which point should we go and impose over the minority in terms of culture, in terms of religion, in terms of lifestyle, and how should we protect the minority? Of course, there is one European response, and probably you've heard about these very big conventions, more than me, actually, because France didn't ratify these two conventions. The first one is the Framework Convention for the Protection of National Minorities, and it's largely ratified, but not by all the countries within the European, within the European Council. And also, this convention is also is only a framework. So that means that all the member states have to translate the terms of this convention through their national policies. Another shortcoming of this convention is that the European Court of Human Rights is not competent on this instrument. We only have an advisory body, so it can be a problem, yeah. And in terms of effectivity, this convention is not that great, I would say, but it exists at least. But for countries like France, Belgium, Greece, Iceland, Luxembourg, it has no meaning. It's not legally binding. And we've got another important instrument, which is the European Charter for Regional or Minority Languages. Here again, France didn't ratify it. We signed it, though. We wanted to ratify it, but I think it's still postponed. So. So you see, for us, for example, it's a problem because the response that we have, the legal response that we have within Europe is not really an answer for some countries like France. Another problem is that should we necessarily enshrine cultural rights only to minority rights? And here we've got the Declaration of Ministries of Culture, which is dated 2003, where all the ministers said that cultural diversity should go beyond this majority and minority dichotomy, because cultures in this way are categorized and stigmatized. So maybe we should think of cultural rights in another way, as only minority rights one. Of course, at European state level, we've tried to define and redefine the rules of living together, and all the models exist around Europe. You've got multiculturalism, you've got assimilationism that exists in France. At European level, the political choice has been for interculturalism. If you want a definition of this notion, you can go to the glossary of the Bush-Otello report. I don't know if you've heard about this report, yeah, and this commission in Canada. They give a quite interesting definition of interculturalism. It's a policy model that advocates harmonious relations between cultures, and it's centered on an integration process that doesn't seek to eliminate differences, but fostering the development of a common identity. So it's about a two-way process, a mutual respect of different cultures and traditions coming to a common identity. So this is the model chosen by the European Council. So should we recognize cultural rights beyond minority rights? Does each person have actually a right to respect of his or her cultural values beyond minority rights? This is the question that we have today. And the the core fundamental civil rights that we have around Europe is, of course, the European Convention on Human Rights. There is nothing said about, or there's nothing explicitly said about cultural rights in this convention. So at the beginning, it's not that obvious that we can acknowledge the existence of cultural rights through this instrument. But more and more people belonging to cultural, linguistic, religious minorities have tried to challenge their rights before the European Court of Human Rights. They didn't always manage, they didn't always win their case, but they tried. And I must say that we can have all the tools in this convention actually to recognize such cultural rights. We've got the right to respect for private and family life. We've got the freedom of religion, the freedom of expression, the right to education, the right not to be discriminated against. All these rights can be used in order to acknowledge the existence of cultural rights. The question is what the European Court of Human Rights does with these tools. And sorry to disappoint you at the beginning of this presentation, but the court doesn't do much, I'm afraid. So this is actually the plan of this morning, but you'll see that some people won the case, and maybe there is a small window in this convention in order to recognize such cultural rights. Of course, the court is recognize the importance of minorities in a democratic society, and the court also recognized the importance of pluralism in our society. The judges actually are fond of harmonious interaction of persons and groups with varied identities, and it's important to achieve social cohesion. And despite all these words about tolerance, pluralism, and the importance in our society, in our societies, in fact, the case law is quite restrictive, in fact. So this is what I'd like to show you through three big topics that are, sorry, I skipped my slides because I've got many things to say, but maybe we can keep that for this afternoon, yeah? So I'd like to tell you a bit more about this case law of the European Court of Human Rights, about linguistic diversity first, then religious diversity, and finally the lifestyle diversity. And I will tell you a bit more about Roma and travelers. So first of all, about linguistic diversity. The convention doesn't say anything about the right to linguistic freedom, yeah? Compared to other instruments like the Charter I told you before, or even the International Covenant for Economic, Social and Cultural Rights, there's nothing about the right to express oneself in the language of your choice. It doesn't exist. Does it mean that there is nothing in this instrument to recognize linguistic diversity? We have many cases about linguistic diversity in different aspects. First, in education. And in education, of course, the court is quite severe with states which actually trying to oppress minorities. For example, there is this case dated 2009 versus Turkey, where students were actually suspended from university just for asking optional Kurdish language classes. Of course, in this case, the court decided that it was a violation of the convention and the right to education. But if we go further, and if we ask for a linguistic accommodation in general, for example, for Belgian people speaking French, asking to have classes in French in the Flemish region, it's not possible. Probably you've heard about this very famous case, the Belgian linguistic case. It's known like this. It's quite old, but it's still update, I would say, because the court said that the right to education doesn't give the right to obtain education in the language of your choice. And the court goes even further, saying, well, that would lead to absurd results because it would open the door to every kind of requests. Yeah. So this is the case law. So there's no obligation to create any school proving lectures in French, even if French in Belgium is one of the 2 official languages. And there's no violation of the respect of family rights, even if the kids have to go very far from their home to attend French classes in the Wallonie region. Let's try not to be so depressed, and there are some cases where the court goes a bit further, but you will see that there are cases that are very, very, very specific that concern territorial conflicts. First, you've got this case, Cyprus versus Turkey. It's a case where actually the Turks who occupied the northern part of Cyprus decided to close all the secondary school which provided Greek classes. And basically the students had to go in the southern part of Cyprus to study in Greek, or to stay in the northern part, but to study in English or in Turkish. In this case, the court decided that it was a violation of the convention to have such a system because it was quite unrealistic to provide a secondary schooling in Turkish after completion of the primary level in another language, that is Greek, yeah? So, but this is very, very, very specific. Another case, which is a bit more recent, dated 2012, which is about Moldova, concerned the effects of the Russification policy that exists in Moldova. Maybe you haven't heard about it, but there is a separatist regime in Moldova. I'm gonna give you a short map. Yeah, you've got this separatist regime in Moldova that actually tried to impose the Cyrillic alphabet for Moldovan language. Moldovan language is written with the Latin alphabet. Yeah, this is the normal language, and there are 3 official languages in this country: Russian, Ukrainian, and Moldovan. Yeah. So this separatist regime tried basically to close all the schools working with the Latin alphabet and imposed an alien language written in Cyrillic. Yeah? So all the pupils had the choice to go back to Moldova, yeah, free Moldova, let's say, to study their proper language with the Latin alphabet. But that was quite difficult, in very difficult conditions. The parents were harassed. You had identity check at the border and so on. Or to study a quite artificial language with no books in the separatist regime region. Of course, as you can imagine, the court decided that in this case there was a violation of the convention because this policy didn't show any legitimate aim, and because of the forced closure of all these schools where all the peoples actually, I think that half of them didn't go to school after a while, yeah? Yeah, of course.
Can you show back the map? I'm from Moldova. So the Transnistria or region, it's separatist, but the other one, Gagauzia, it's like Gagauzia Otah, it's called. There, it's still actually permitted the access of Moldavian language in schools and also in universities. So Gagauzia, just quite moment about Gagauzia, because it's not all those parts are separatists. Gagauzia still permit education in Romanian language, so in official language of all Moldova. That was the quiet moment about
Very
this.
interesting, I learned a lot. Yeah, we'll
Thank
have
you.
a discussion about this, yeah?
Yeah.
Yeah. Which actually supported this separatist regime, yeah? Okay. Yeah, well, I come... On linguistic diversity in political life, we also have case law, yeah? And again, the court is really not in favor of any repressive system like the Turkish one, which actually tried to criminalize the use of any language other than Turkish during the election campaign. This law was modified, but at that time, yeah, the candidates tried to speak in Turkish with the people around them because they were not able to speak Turkish, yeah? So it was, let's say, in a private relation that the candidates tried to speak in Kurdish, which is not an official language, but Kurdish people are quite a big minority in Turkey. So this blanket ban, plus the fact that it was criminalized to use this language in private relations, was of course condemned by the court through the violation of Article 10 of the Convention, which enshrine the freedom of speech. Yeah. But apart from that, candidates also try to challenge before the court the right to express themselves in the language of their choice within the representative assembly. And the court didn't dismiss the cases. We've got cases against Belgium, against France. Maybe we can go into details afterwards, but the court didn't recognize such rights. It's also the same with a candidate in Latvia who actually had to pass an exam to prove her sufficient knowledge of Latvia language. You probably know that there is a big minority, more than 40% of people who are living there, who actually are Russian-speaking population. So this candidate was Russian-speaking, and she had to pass this exam just to be a candidate within the parliamentary elections. She actually failed this exam, and she tried to challenge this system before the court. And again, she didn't win her case because the court decided that it was legitimate for a country to ensure that the institutional system functions properly, meaning that we work in one single language within the parliament. So you see that the case law is quite restrictive. It's even more restrictive, let's say, within administrative bodies. You cannot choose the language you want to speak with public administrative bodies. This is what the court says in another case versus Latvia. And you also have no right to obtain the transliteration of your name and forenames outside the rules of the national alphabets. Again, the case law is very restrictive in this linguistic diversity existing in Europe. The only, let's say, core rights that we have are the ones that are directly and expressively provided within the European Convention. And these are the Article 5 and 6 of the Convention, giving the right to be informed of the reason of arrestation, giving the right to be informed in a language that you can understand of the nature and the cause of the accusation, and also have the right to be assisted of an interpreter in case you're in court. Yeah, so only in these cases you have the right to use the language of your choice and to have the right of an interpreter. Otherwise, I would say that the case law is quite strict. Well, there are other cases about prisoner, but maybe I can skip that to come to the religious accommodation. Again, the case law of the European Court is quite restrictive, and basically there is no valid justification to belong to a specific religious minorities to opt out the general rule applicable to everybody. Yeah, and usually the court finds that we've got pressing social needs to stand to these general rules, like secularism, sex equality, security, right and freedom of others. You probably have heard about all these cases that existed in Strasbourg, so I won't go into details. Maybe we can come back to this during the discussion. But the European Court basically justified the prohibition of headgear and headscarves for many people, like civil servants, students in Turkey, pupils of primary and secondary schools in France, during security checks, again, cases concerning France, and official documents, case against France. Yeah, so maybe we come back to this later. But one first remark is that this case law is quite the opposite one as the one of the human rights community case law, because we've got two cases, again, against France, challenging first our legislation banning ostentatious religious signs at schools, and the other one providing for a bare head on official documents. In these two cases, France was convicted for not bringing evidence of this of the benefits achieved through this legislation compared to the sacrifices of these minorities, and in these cases, Sikh people, yeah, wearing the turban. And one important thing is that the committee decided that the turban was not even only a religious symbol; it was also a component of their identity and their physical integrity, which is another dimension that the court completely skips. The court, as the European Commission of Human Rights, the former one, actually had developed for many years the resign doctrine. What is this resign doctrine? Well, the court decided on many cases about religious discrimination that people had always the freedom to resign. Yeah, in case, for example, where working hours do not fit with their religious requirements and practices. It's a bit short, I would say, and when I presented this to my Canadian colleagues last year, everybody was laughing, actually, yeah, because especially during the period of crisis where it's not really a freedom to resign, yeah. But even in 2012, the court decided so about a Jewish lawyer who actually couldn't attend and defend his client because the hearing was supposed to happen the day of Yom Kippur, which is a Jewish celebration day. The court decided that it was not even a matter of religion because the applicant could carry out his religious duties. He had no pressure to change his religion. He could have arranged to be replaced. So there was no problem. And even if there was an interference with his religion, well, there were social pressing needs like the proper administration of justice and the right to have a case be heard within a reasonable time. So in these cases, the court considered that there was no violation of the convention and the freedom of religion. There were 3 judges actually dissenting on this opinion, yeah, and they considered that the court showed little understanding of religious minorities' concerns, yeah, and they said, well, having no pressure to change a religion is not a guarantee of freedom of religion, and I actually agree with this position of the dissenting judges. It's quite striking because on another case, 2 years before, versus Russia, it was another case on gender discrimination in Russia, but military serviceman who actually was not entitled to take his parental leave compared to his female colleagues. And in this case, actually, the Russian Constitutional Court said that, well, this guy was free to resign. If he wanted to nurse his newborn children, he could have resigned. And in this case, the Chamber Court said, well, this is particularly striking, yeah, because it's not really a choice to be free to resign. But you see that on gender discrimination, it's striking for the court, but on religious discrimination, it's not that striking. It has changed very recently, but we will see. We'll see what's next, but it has changed in 2013. For the first time, the same day, the court gave 4 different cases. This is only one, Evada versus United Kingdom. And it was the case of a woman who was a member of the checking staff of British Airways. And she wanted to wear a visible cross. She's Coptic, and she wanted to wear this cross. That was against the clothing in-house rules, and I think that she was not really dismissed, but she was not able to work in direct contact with the clients. In this case, it's true that the court decided that maybe the better approach is no more the freedom to resign doctrine, but it's more a question of balance of interests. And the idea is to weigh the possibility of changing jobs with the restriction of religion expression or practice, yeah? And in this case, the court, for the first time, it's one of the very small number of cases where the court decided that there was a violation of Article 9. In this case, the court considered that British Airways just wanted to defend or to protect a corporate image, and it wasn't heavy enough to prevent these women from wearing a cross in a visible way. And by the way, they changed their practice, and now she's allowed to do that. Another case that you probably know, maybe I don't need to go into such details about Luminous versus Greece. Have you all heard about this case? No? Maybe I should say a word about that. Another case coming from the Grand Chamber gave also a right to a Jehovah's Witness who actually was convicted because he didn't want to wear the military uniform. He didn't want to go to the army. And after that, he passed an exam, a very difficult exam, to become accountant. But accountants in Greece cannot practice if they've got criminal convictions. So in this case, this guy had passed the exam, but he had this criminal record because of his religious beliefs. Yeah. So in this case, the court decided that Greece failed to introduce appropriate exceptions. And here you will find the terminology of reasonable accommodation coming up in European courts case law. So this is a very important case. There is another one which is a bit more recent, which is about a prisoner in Poland wishing to have vegetarian diet. And it was more the conviction of the bad faith of the national authorities and the prison service, because they didn't want to provide these meat-free meals, but just like this, because there was no additional costs, there was no need to prepare anything, a meal in a prescribed manner, there was no specific requirement, there was no disparate impact on the other prisoners. So in this case, the court decided that Poland actually violated Article 9 on freedom of religion. Yeah. So again, it's a kind of accommodation of the food constraints of this prisoner, but it's not quite clear whether it's a reasonable accommodation that will be provided in every of these cases. And the more recent case law shows that even if the court uses the terminology of reasonable accommodation about taking reasonable and appropriate measures and so on, the cases are dismissed. Yeah, in all these cases, like the one against Latvia and the other one against Romania, where prisoners try to perform their rituals, to read and pray on their own, or to burn incense sticks, to hear a cassette player and their tapes. In all these cases, they were dismissed. Where am I? Do I still have time?
Yeah. We have
Yeah?
5-10 minutes for the poor gypsies.
For the poor gypsies. Okay. Maybe I can skip the part on religious diversity, but we can come back to this according to the French policy and the policy around European countries. But it's interesting, so maybe I skip this and I go to the Roma and travelers issue. So the Roma minority in Europe is one of the biggest in terms of figures. It's the most significant minority in Europe, in Romania, Bulgaria, Hungary, Serbia, Spain, and France. It's about 10 to 12 million people who are highly marginalized. Initially, they have been itinerant. Now they live more and more in a sedentary way, but most of the time in mobile homes. And they have, well, they practice Romani language too. The court, again, as I said at the beginning of this presentation, recognized the importance of pluralism and in our democracy. In concerning the Roma and the Gypsies, the court recognized the particular vulnerability of this minority. And the fact that special consideration should be given to their needs and their different lifestyle. Again, the court uses this terminology of reasonable accommodation, saying that the states have a positive obligation to protect and respect this lifestyle. And even if it's not a way to be exempted from general law, it may have an effect on the matter on which, on how the law actually would apply. So this is said in many cases, like Chapman versus UK or Minorities versus Spain, that you probably have heard about. But again, if you've got these strong assertions from the court, coming back to the concrete rights, there's nothing, I must say, because the court considered that, Roma shouldn't be considered as being treated in a worse way than anyone who would like to live in a caravan and find it's disagreeable to live in a house. So again, no specific consideration for this very specific lifestyle of Roma. And in Chapman versus UK, it was the case of a woman who actually wanted to occupy the land without planning permission. But she didn't find any equipped sites around the UK to stay in her caravan. So she stayed in this place where she had no permission to. Again, and she was convicted for that. Again, the court said that there's no obligation for the states to provide an adequate number of equipped sites within Article 8, which is about respect of private life, because this Article 8 doesn't give the right to provide a home, housing. Again, it's quite striking compared to other case law, like the one of the advisory committee of the Framework Convention, but also compared to the case law that we have also in Strasbourg within the European Community of Social Rights. Probably you've heard about this advisory committee. Is responsible for monitoring and having all the claims coming concerning the European Social Charter. And in this case, but in other cases too, against Belgium in 2012, Belgium was convicted because Belgium didn't provide adequate number of sites accessible to travelers. They had no planning legislation to take account of travelers' specific needs. They didn't recognize caravans as dwelling, and so on. And in this case, the European Community of Social Rights said that travelers' families are not in the same situation as the rest of the population, and appropriate social measures should be taken, and the situation would call for differentiated treatment to improve their housing conditions. So we are very far from the European Court restrictive case law in this sense. And of course, the community concluded that there was a violation of the revised social charter in the case of Belgium. By the way, France was convicted many times by this committee, but less on, well, on housing too, but more on the conditions of stay and also the situation of schooling and non-schooling of Roma people in France. Another case, Menos Diaz, probably you all know about this one. Should I skip this one? No? You want me to address this case? Well, I tell just a small word about that. It's not really a right to accommodation that was provided by this case, but it's nevertheless interesting. It was the case of a woman who was married according to the Roma community's own rights. She was not married in a civil way, yeah. But at the time she married, it was not possible anyway. It was only the only marriage that was possible. It was the one in accordance of the Catholic way, the Catholic Church. And after the death of her husband, she tried to obtain a pension, a survivor's pension. The Spanish administration refused it on the basis that she was not validly married to get this pension. She won the case before the European Court. Why? Not necessarily because the European Court decided that there was an equivalence between the two kinds of marriage, the civil one on one hand, or the Catholic on one hand, and the Roma one on the other hand. They just considered that these women had a legitimate expectation to have her marriage recognized as valid, because for more than 19 years she had received health coverage and collected social security contributions as if she was validly married. She had even a family record book. So in this case, it's more about the good faith of the applicant and the bad faith of the national authorities. Than a very specific right to reasonable accommodation, because there are other cases after this one showing that women would try to have accommodation like the one in Turkey, who wanted to have the recognition of a religious marriage through the Muslim rights, or another case versus Greece about a woman cohabiting with her ex, well, her dead, not spouse, but partner. All these women were dismissed in their cases. Conclusion? So you see, it's a bit depressing as a picture, but there are some applicants who actually gained rights on the basis of their identity. But the trend is not really the one of a complete diversity and the right to accommodation, let's say. And in this sense, it would correspond to the defense of national identities that we all live in our territories, I would say, yeah? Especially within the religious sphere. But it doesn't mean that if we have nothing in the European conventions of human rights case law, if we've got nothing in this case law, or not that much, let's say, it doesn't mean that we don't have anything in Europe to accommodate diversity. Many European states accommodate diversity of languages through local initiatives, for example, but also through the market initiatives. Many private companies accommodate working hours during Ramadan, for example. And there are also interesting case, though, about religious accommodation, for example, in the UK or in Norway. I may have a word with you about it later on. So the only thing is that it's not that visible. And this work of making a collection of all the good practices that exist around Europe would help to define a minimal standard of protection and to draft guidelines to accommodate diverse cultures. And maybe the court will find a real consensus existing in our countries to accommodate diversity. So thank you for your attention, and I'm open to every question that you may have.